Hi, this is Dr. Nivedita Srivastav, and as the convener of the Women Tech Wing GESIA IT Association, we've been having several conversations with tech entrepreneurs, medium-sized businesses, large-size organizations in the tech domain, and they've been coming up with this challenge or with this query that they have come back to us each time, that how do they kind of prep themselves up for legal nuances and government norms when they initiate their business or when they're setting up their businesses. So considering that, we've been thinking of bringing up somebody who's an expert in the legal domain, especially for tech industries. And yes, one name that came up on everybody's mind was Advocate Mr. Bhargav, right? And he was very kind enough to take up our invitation in the very first go. So of course, I would like to welcome Mr. Bhargav there. And yes, let's listen it out from him, what he has to say about the various challenges that tech organizations face, which is about employee contract or client contracting or various other norms that, that any size organization has to face, right? Yes, we would love to hear your feedback, and we look forward to having an amazing podcast with our very own chairman, Mr. Pranav Pandya, and Mr. Jaydip with Mr. Bhargav. We would love to hear from you about and have a feedback as to how you enjoyed this podcast, because we look forward to setting up a help desk which would help you solve your legal challenges with the help of Mr. Bhargav out here. Looking forward.
Hello friends, welcome to our first podcast by GESIA. So today we want to host our guest, which is we are about to reveal soon. But this podcast is by one of the GESIA wing, which is Women Tech Wing. So we that wing want to have you lot many things for you, especially lot many knowledge for our IT companies or electronic companies, and they are coming out very well designed knowledge series. So part of that knowledge series, we are hosting this podcast. And for more detail, I will just want to hand over to our chairman, Pranav bhai. Pranav bhai, over to you.
Thank you, Jaydip. And hi, Bhargav. So, as GESIA IT Association's honorary chairman, I would like to convey this message to everyone that, as Jaydip was just now saying, that Women Tech Wing is an entity within a GESIA. It's a subset of GESIA. And it is meant for the tech entrepreneurs overall, so irrespective of them being women or men. So all tech entrepreneurs of electronic and IT industries can be covered and encompassed by the activities of Women Tech Wing of GESIA. And it is not only specific to something that we are going to do in Ahmedabad. We are going to this series of knowledge sessions and knowledge activities spanning across the state. So we'll be dividing the state into 4 regions, which will be, besides Ahmedabad, it will be Rajkot, then it will be Surat, and then Vadodara. We already had some sessions prior to this. Now the podcast categorically has been designed in such a way that there are many aspects pertaining to a tech industry. So whether it is from IT or software or hardware or electronics, when they function, they are supposed to have many activities which is going to be carried out as a part of their governance. So एक कंपनी चलाने के लिए हमें HR का nuances चाहिए. Now HR again is covered by various statutory requirements. Similarly, कंपनी को खुद को फंक्शन करने के लिए काफ़ी स्टैट्यूटरी रिक्वायरमेंट्स होते हैं. तो वहाँ पे लीगल जो पर्सपेक्टिव है वो हमें देखना होता है. एंड एज अ कंपनी और माई सेल्फ आई एम को फाउंडर एंड चेयरमैन ऑफ देव IT. तो हम जो फेस करते हैं काफ़ी जो कॉन्ट्रैक्ट्स हमारे होते हैं विथ क्लाइंट्स और विथ सप्लायर्स और टू दैट मैटर इवन द एम्प्लॉय कॉन्ट्रैक्ट्स, वहाँ पे कहीं ना कहीं परसेप्शन डिफरेंसेस आते हैं. ह्यूमन बीइंग्स है, डिफरेंसेस होते हैं, बट दे आर ऑल गवर्न अंडर द फ्रेमवर्क डिसाइडेड बाय द लॉ ऑफ द लैंड, लॉ ऑफ आवर कंट्री, एंड देयरफॉर वी नॉर्मली बैंक अपॉन टू द लीगल एडवाइसेस. लेकिन काफ़ी बार हमारी कंपनीज में हम देखते हैं कि जब कुछ होता है तब हम ढूंढने निकलते हैं. तो बेस्ट प्रैक्टिस क्या होना चाहिए हमारे वहाँ शुरुआत से ही कौन सी चीज़ ऐसी रखे कि कंपनी के गवर्नेंस पॉइंट ऑफ व्यू, कंपनी के फंक्शनिंग पॉइंट ऑफ व्यू, एंड सिमिलरली फ्रॉम द HR के गवर्नेंस एंड HR के फंक्शनिंग पॉइंट ऑफ व्यू, ये चीज़ मायने रखे और पहले से एक तैयारी करके रखे, ताकि जब हम लीगल एडवाइसेस लेने जाएं तो फंडामेंटल्स इज बाय एंड लार्ज कवर्ड. तो ये चीज़ को ध्यान में रख के आई थिंक जयदीप भाई के साथ हम बैठे थे और डिस्कशन कर रहे थे गेशिया बोर्ड मीटिंग में. ही इज़ वन ऑफ द इन्वाइटेड एंटिटीज, अ पार्ट ऑफ आवर वेरियस एक्टिविटीज़. तो वहाँ पे ये बात निकली कि पॉडकास्ट क्यों ना किया जाए, और ये चीज़ को फिर हम हेल्प डेस्क के हैसियत से भी चालू करेंगे. वंस वी हैव दिस पॉडकास्ट इन प्लेस, उसको देखो, हमारी IT फ्रेटर्निटी उसको पूरा देखें, और उसके अंदर जो भी उनको क्वेश्चंस आगे जाके पूछना है, कोई भी क्वेरीज है, कोई प्रश्न खड़ा होता है, या तो वो कोई फेस कर रहे हैं करंट सिचुएशन, उसके बारे में उनको डिस्कस करना है. तो हमारे कलीग यहाँ पे आए हैं जो खुद एडवोकेट हैं, प्रैक्टिसिंग एडवोकेट हैं, वो उसके बारे में बातचीत करेंगे. सो विद दिस आई वुड लाइक टू इनवाइट पीपल, ये देखो, ये सुनो, समझो, जो भी क्वेरीज है वो गेशिया में ज़रूर आप भेजें. भी डिस्कस कर सके उनके साथ. So with this, thank you guys for coming up with this podcast finally, and thank you Bhargav for sparing that time. I'm very happy to have this happening today. Jaydip, over to you.
Thank you.
Take it forward.
Sure.
और आपकी इच्छा है तो कैंडिड कन्वर्सेशन में जहाँ ज़रूरत पड़ेगी, I will come forward and be a part of the conversation.
We are looking for mentors like you, or in other words, as this is legal, we might face some legal issues as well in your company.
Correct.
So we want to understand that nuances, how
Correct.
you
For
work
sure.
out. We'll take entrepreneur aspect from you. We'll take legal aspect from Bhargav. So many people who are watching, they can understand which kind of problem. So there are, I mean, if you're scaling 0 to 10, that different problem. If you're scaling 10 to 100, that different problem. Today's guest is Bhargav bhai. So he's a practicing advocate. And I was just behind the scenes, I was telling him, I don't want to introduction you because अगर कुछ गलत हो गया आप sue कर दोगे. So I'll ask him to introduce himself so he can give more details. And which is Bhargav, when I say introduce yourself, keep in mind you are talking with IT people. So just show that side to our audience.
So tech fraternity, यहाँ पे electronics, IT, software, hardware सब लोग हैं.
सब लोग, exactly.
HR practitioners भी हैं.
Noted. So thank you Jaydip bhai, thank you Pranav ji for a very kind invitation being extended by you guys here, and thank you for the GESIA Women's Tech Wing also for organizing this particular podcast session. I would want as many tech professionals and entrepreneurs to be benefiting from this, because as my profession also states, it's a constant learning process. I would want everybody to learn and imbibe more knowledge and consume more knowledge by this session. Having said that, I'll just give a very brief introduction of myself. I am the founding partner of a law firm named Trine Partners. We are headquartered here in Ahmedabad. We have an office in Mumbai as well. We practice in 4 major spheres or areas of law, so to speak. The primary being corporate and commercial law. Second is employment law. The third is intellectual property, and the fourth is disputes. So insofar as the tech professionals and IT companies in Gujarat are concerned, we are assisting with numerous IT companies with their daily routine struggles and issues that they face on a day-to-day basis. And we essentially and effectively tend to make their lives easier by providing our legal inputs so as to get their internal systems streamlined.
Perfect.
Right, so that's what the introduction is. I would want this podcast session to be covering anything and everything that encapsulates that might come in the journey of a tech company. So Jaydip bhai, we'll keep that in mind and then we can make it a very interactive session. If you guys have any questions anywhere, please don't hesitate to interrupt me.
Surely.
If you feel कि ये topic हमने cover नहीं किया, if you want certain scenario kind of answer, so we can again invite Bhargav bhai or any related person for the talk, and we can host one more podcast for you. So rather than I'll say subscribe this channel, I'll say comment on this, share your perspective and ask a question.
Perfect. That is what we wanted.
Exactly. So before Bhargav, we move to a specific question. I just want to understand out of your career, which is some interesting use case you've been to, especially when we talk about tech wala things. If you can start with that, so people can relate more, and then we move to very specific questions.
Okay. So if you're talking about intriguing scenarios that I might have come out in the usual course of my work, career is a very broad term that we're speaking here. I'll just restrict it to work, right? So, so in the course of me working with a lot number of professionals, and this observation is not just limited to IT companies, it is extended to all companies of across different streams, industries, so on and so forth. But there is one very peculiar observation that I've had, and that is still sustaining, is that I understand that whenever a company is building itself from the very scratch, whenever an IT professional or any other professional for that matter incorporates an entity and treats it like a baby, the primary focus of that particular entity or person will be there on the primary element of the business. Supposedly, if a tech company is being incorporated to further artificial intelligence, the primary focus in terms of devotion of resources, whether money or otherwise, is going to be towards the primary element or core of the business. Right. But at the same point in time, there are certain tertiary elements of the business. I'm not just restricting tertiary elements to legal issues or legal compliances or legal agreements. I'm extending it further to secretarial compliances. I'm extending it further to financial compliances.
Correct.
All of these tertiary elements all put together as a bundle play a very pivotal role in the furtherance of the primary interest of the company.
Very, very correct.
Right. So just giving you an example here, Pranav ji and Jaydip bhai, is that supposedly assume that a company which is a startup entity is in the process of raising a pre-seed round, right? When it raises a pre-seed round, which might be a mixture of debt and equity or whatever, right? At that particular point in time, the investor or the lender, as the case may be, would want a due diligence to be conducted of the target.
Absolutely.
Whenever a due diligence is conducted of the target, what is seen is that not just the primary element of the business, but the tertiary and back office elements of the business that impacts the primary element of the business. So therefore, for any IT company, I understand that you might have limited amount of resources at the very beginning, you might have limited amount of money at the very beginning, you might have a limited team, but at least some focus should also be spent on the tertiary elements so that those lack of focus on those tertiary elements are not impacting you tomorrow.
Perfect.
That they're not pinching you hard tomorrow. I want it to go hand in hand.
Makes sense.
So that is one very interesting observation that I've had. And that is one observation that I'm wanting to put into action and eliminate it from all tech companies in Gujarat at least.
So a small interjection here. Normally, ગુજરાતીમાં કહીએ તેમ કે બિઝનેસ જે કરતો એ વ્યક્તિ પોતાના બિઝનેસ પર જ ફોકસ કરે છે. जो बिजनेस करता है वो बंदा बिजनेस पे ही फोकस करेगा, जो मेन पॉइंट है उसके ऊपर फोकस करेगा. He wants to deliver that thing and naturally would like to earn out of it and create a good name and just go on and on and on. That is where जो भार्गव जी बोल रहे हैं कि छोटी छोटी जो चीज़ें होती है वो हम मिस कर जाते हैं इनिशियल स्टेज में. और बाय द टाइम आप एक लेवल पे स्केल करो, ऑटोमेटिक यू आर अंडर द lenses and purview of statutory compliances and authorities and entities. तो वहाँ पे वो क्वेश्चन स्टार्ट होते हैं. फिर भी हम पीछे जाते हैं, वापस सब ठीक करते 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 आगे आते हैं. What I agree with him is कि अगर पहले से ही, या तो हम ऐसे इकोसिस्टम एज गेशिया ही हमें शायद ऐसा कुछ एक फैब्रिक खड़ा करना पड़ेगा, या तो एक फैसिलिटी क्रिएट कर सकते हैं साथ में मिल के. ऑब्वियसली अकेले से कुछ नहीं होगा. कि कोई भी इस तरह से नई कंपनी बनती है तो यहाँ पे उनको पहले से इस तरह से गाइडेंस मिले विथ पर्सन लाइक हिम देयर, तो वो एक चेक्स एंड बैलेंसेस करते करते आगे बढ़े, एंड दैट वुड रियली हेल्प. सो दैट ड्यू डिलिजेंस फाइनेंस का, ड्यू डिलिजेंस सेक्रेटरियल प्रैक्टिसेस का, कंपनी सेक्रेटरियल प्रैक्टिसेस ऐसा जरूरी नहीं कि जो लिस्टेड एंटिटी उसको ही करना है.
Precisely.
वो सभी कंपनी के लिए जरूरी है.
Precisely.
बट एनीवे आई एग्री विथ यू, जरूरी है.
सो फ्रेंड्स, जनरली कोई भी डिस्प्यूट होता है तो हम बोलते हैं कोर्ट में देख लेंगे. बट वो देख लेने के लिए आपको पास क्या लीगल स्ट्रक्चर है, क्या एंटिटी, क्या आपने पहले से प्लान किया है. सो भार्गव, आई वांट टू अंडरस्टैंड कि जब भी वी राइट लीगल कॉन्ट्रैक्ट्स आइदर विथ आवर वेंडर्स, आइदर विथ आवर एम्प्लॉयज़, आइदर विथ आवर सर्विस प्रोवाइडर, सो क्या ABC काइंड ऑफ स्टफ दैट इज़ नॉन नेगोशिएबल हमें पता होना चाहिए, या लाइक प्रणव भाई से SOP जैसा कुछ है. So, ये 3-4 चीज़, few things are must, few things are should, few things are could. तो if you want to bifurcate those things, तो क्या क्या हो सकता है? Very brief and थोड़ा टेक वाले बंदे समझ में, not
Correct,
pure
correct.
legal language.
Understood. So firstly, I'll take a step back as a precursor, and we'll first dwell on the fact as to why is it important for any company, more particularly tech companies, to have the legal contracts in place, right? So the requirement of a legal contract emanates from the fact that you would want to mitigate your risks in the future, right? That is one primary element. You would want to mitigate your liabilities that may be ensuing upon you in the future. कल जाके आप कोई भी ऐसा agreement draft कर दोगे, अगर उसमें unlimited liability का clause होगा, so you would definitely not want that unlimited liability to be falling on your head, right? So therefore, it is extremely important for the parties, even if they have to spare some more time. I understand the excitement out of a business owner that they want to incept a business relationship.
जल्दी करो.
हाँ, मैं जानता हूँ, as a person who had incepted my law firm itself, I was also very keen in onboarding clients in the very first thing. But it is extremely important for us also to be noting that before we incept a relationship, let the things be clarified. Let everything be clarified. Even if it takes some more time, even if it takes some more resources, even if it takes some more amount of energy that is being spent by the business owner and the client also, so be it, right? Okay. So there should be mitigation of risks. If you have a well formulated contract or a well crafted contract which takes care of all of those things holistically, you are minimizing the possible litigations that might happen in the future. That is second. Purpose of a well drafted contract is to ensure that you are looking for a solution from the contract whenever you are referring to it, right? You draft the contract today, right? आप कोई भी IT company है for that matter, they might have an agreement drafted and crafted today with a client. That engagement of the said IT company might go on for the next 2 years. There may be multiple statement of works and added as annexures to the said MSA that is being drafted. But eventually after 2 years, fortunately or unfortunately, there is कोई अनबन हो जाती है उन दोनों पार्टियों में. At that particular point in time, after 2 years, an agreement is going to be plugged out from your system, which has not been referred for the past 2 years. Yes. Right? So you don't remember anything that has happened in the past 2 years.
Correct.
At that particular point in time, you should be referring to an agreement as a Gita to find a solution, not to create further problems. Right? So therefore, there should be a solution that is embedded in the agreement so that we can merely pluck that flower from the agreement and solve our matters.
Garden of agreement.
Right. So the purpose of an agreement is that it is to eliminate ambiguity, eliminate any kind of uncertainty, and at the time when you are formulating an agreement, I am wanting both the parties to consult their respective legal counsels and dwell on the possible problems that might occur in the future and carve out a solution for that by way of mutual discussion and capture it in the agreement today itself. That if this problem occurs in the future, then we are going to be dealing with this problem in this manner. This is written in the agreement.
Perfect.
So how much ever we can apply our brains, we can apply it. We can capture all of those problems and solutions in the agreement so that all of those problems are resolved amicably in the future without any litigations.
Right. In short, आप जो बोल रहे थे कि लॉयर होता है वो sue करता है, he is in fact saying sue नहीं करना है, litigation नहीं करना है, agreement ही ऐसा बनाओ उन लोगों की मदद से.
नहीं, completely second on what
next podcast onwards we will ask our speaker to submit their bio कि वही हम बोलेंगे.
नहीं, see, it is not just that. On a very lighter end, even if there is a litigation that is to occur in the future, अगर दोनों पार्टी नहीं मानती, even if there is a solution that is embedded in the agreement, after a point of time, if that is a battle which is not in the worldly realm and that is not understandable, and the people are wanting to go ahead and institute a litigation against one another, the agreement will nonetheless help the parties.
They will.
Right? Because an enforceable agreement, if a proper well-crafted agreement is there, which is stamp dutied, accordingly whatever compliances have to be followed to ensure that the agreement is enforceable, which is then placed before a court of law, the court of law or the judicial forum dealing with the said agreement will also be able to interpret and draw inferences from it in a very nuanced, in a simple manner.
Perfect. नहीं, so वही मैं बोलने जा रहा था कि जो आर्बिट्रेशन वाले जो आर्बिट्रेटर होंगे या तो जज होंगे कोर्ट में, वो वही डॉक्यूमेंट को अच्छे से रिफर करेंगे, हमको ही बताएंगे कि डॉक्यूमेंट खुद बता रहा है तो आप समाधान करो.
Exactly.
The things will move rather faster and be resolved faster.
Correct. Without hurdles, without hiccups.
Exactly. I agree with him. I thoroughly agree with him. काफी आज जैसे आप बोल रहे थे in the rush कि नहीं धंधो आवाज जल्दी साइन करो, एग्रीमेंट साइन करो, but it's better to sit back and have a look at it.
So those who are starting, one of the example I want to say from my own journey. So we lost our client, US client, I guess 8-9 years back, and at that time we realized how much SOPs very much required. So it's technically not a legal document, but internal client को पता होना चाहिए what we are going to do.
Correct.
And due to that reason, we lost our first international client, and then we realized, okay, these are the things we are missing. So, I mean, we are lucky enough, we are not facing any legal issues till date. But just in case, so this is a practice. So if you are starting a new business, if you are a tech company and you are planning to do that, so documentation is very much required, irrespective of SOP, irrespective of legal, irrespective of HR. So you should start practicing those things, so that will help you once you grown like Dev IT.
Oh, there are many other
or
companies.
many other companies.
In
for
fact,
matter.
small companies also. So master service agreement is something that becomes the Gita, as
Right.
Bhargav ji was saying. Master service agreement between you and your client.
Right.
And again वो एक चीज और उन्होंने बोली कि दोनों साइड को इक्वेट करके रखना है. It's kind of a win-win thing.
Correct.
We have to look out for.
Makes sense.
ये चीज मुझे डिलीवर करनी है, सामने मुझे उसका सर्विस चार्जेस मिलेंगे, और वो एग्जीक्यूशन में कहीं आगे पीछे होता है तो उसको कैसे रिजोल्व करना है. दैट इज द बेसिक एसेंस.
Perfect.
Correct.
So Bhargav, that leads me to another question. So when we talk tech companies, उसमें बहुत सारा bifurcation होता है. सर्विस कंपनी होती है, प्रोडक्ट कंपनी होता है, सर्विस फर्स्ट और प्रोडक्ट फर्स्ट काइंड ऑफ होता है. हार्डवेयर कंपनीज होती है, हमारे में इलेक्ट्रॉनिक्स कंपनी होता है. So is there any legal difference as per contract or anything concern, और 19-20 का फर्क होता है, या फिर फ्यू थिंग्स, जैसे प्रोडक्ट कंपनी है तो आपको ये 2 चीज़ या 5 चीज़ आपको बहुत ध्यान रखना है. इफ यू सर्विस कंपनी, सो एक्स थिंग्स आपको, वो तो देयर इज नॉट नेगोशिएबल काइंड ऑफ स्टफ. सो व्हाट आर न्यूएंसेस और व्हाट आर इनसाइट फॉर
Correct.
वेरी स्पेसिफिक कंपनी?
एक तो थोड़ा सा ऑन अ लाइटर वेन, जैसे आर्टिफिशियल इंटेलिजेंस में आप वो LLM को एकदम सॉरी
Yes.
ऐसे नीश करते जा रहे हो, वैसे लॉ में भी है.
एग्जैक्टली होगा.
So I think he will come back
नहीं,
with the
नहीं,
niche
sure.
thing.
सो वही हमें बाहर निकालना और हमें आपको सब सिखाना है. सो दैट्स व्हाई वी कैच हिम. प्लीज भागो.
Yes, Jaydip bhai. So, to the basis of my limited understanding that I possess from my work, a product-based company, as far as I understand, is essentially a company which is in the business of developing a solution or a product, and the said company is wanting to make money or monetize that particular product for furthering its business interests. Correct? Now, there are multiple ways through which the said product can be monetized. One mode is a reseller mode. One mode is a distribution mode, which is similar or synonymous to a reseller mode. One mode is an assignment mode. One mode is a licensing mode. Fifth is if you're a D2C business or you're a B2C business, so to speak, you might directly offer it as a subscription model to your consumers. Just like you have all of these e-commerce platforms and so on and so forth, SaaS-based models and so on. So similarly, whenever your product is concerned, any agreement for that matter, all of these 5 mechanisms and any other mechanisms that people might want to avail in the future for furthering their business interests, a product-based company, the most pivotal or the most crucial part of a product agreement, whether it be a reseller or distribution, anything, is the IP associated with it.
Okay.
Right. As compared, a stark difference between a service-based agreement and a product-based agreement is the IP rights or IP ownership rights associated with the said product developed by the developer, which is the company,
Right.
IT company. The ownership rights over the said product have to be defined in the agreement. To what extent it is going to be assigned or licensed to a particular individual. If it is going to be licensed to a particular individual, what all rights have been granted to the licensee, as you being the licensor, being granting that license, right?
Right.
And fourth, that if there is any infringement happens or any passing of action that happens in the course of the licensee or the reseller utilizing your IP rights associated with the product, what is the mechanism of dealing with the same?
Perfect.
Right. Most important, the rights or majority of the cases, the IP rights associated with the product stay with the developer itself, because it is his product or their product that they have developed by their own resources and time and energy. So it belongs to them. They have to monetize from it. As compared to a service business, we are essentially, say, any IT company in the business of providing a service might also be developing a product for another individual.
Perfect.
Right. But that product does not belong to them. It is
Right.
taken as a service. A solution is being developed for another person. So XYZ company might be engaged for developing an e-commerce platform. Right. So therefore, that's a product. That product has been developed by the XYZ entity, which is a service provider, and that entire deliverable which provides for the solution is handed over to the client on the receipt of the entire compensation and emoluments stated in the agreement.
Perfect.
Right. So, insofar as a service agreement is concerned, since I've already taken up the point of an IP right, I'll just pull this thread a bit more further. And I would want to clarify that when can there be certain restrictions on transferring the IP associated with the service that has been provided by the service provider.
Okay.
Supposedly कोई एक सर्विस प्रोवाइडर ने अगर 10 चीजें करनी है एक पूरे प्रोडक्ट को बनाने में, उन्होंने 7-8 चीजें कर दी है, ठीक है ना, but after that the payment stops coming from the client, right? At that particular point in time, what all rights are associated with the
we relate to this.
We can totally relate, and if you are watching this, you can totally relate. पैसा नहीं आएगा तो क्या करेंगे? Please, Bhargav.
So it is after you have already, I'm coming back, that there are 10 different things, 10 different modules that are required to be undertaken.
Right.
7 are already undertaken. I have been paid for 5 of the modules. Now the payment might happen on a milestone basis. The payment might happen on a monthly basis. There are many number of modules
Yes.
that the
Yes.
parties may
Models there.
model the parties may devise. Right. Now assuming that out of 10 models, I'm being paid individually for a milestone for every module that I have prepared and delivered to the client. He's satisfied with the first 5 modules that I have prepared and delivered. After the 6th module, I submit it to the client. The client is satisfied, but the money stops flowing in. What do I, as a service provider, have a right to do as per the agreement?
Okay.
Right. Now, as per the agreement is a crucial factor because whatever you can do has to be in the contours of the agreement.
वापस agreement आया.
So we need an agreement.
Yes. So the agreement should capture all of that in detail. So what is it? Supposedly those 5 modules that have already been prepared by the service provider company and I've been paid for it. Right. I've been adequately paid for it as per the agreement. So the IP rights associated with the first 5 modules that I have developed and provided to the client and the money has come in belongs to the client. But anything thereafter, if I have not been paid, there is generally a right that is there in the agreement which can be mutually discussed between the parties per se. That is all subject to discussions. But generally, it should be the case, ideally, that the service provider company should have a retained or a withholding right over the said IP that is for the 6th module and 7th module and so on, till the time that the entire payment comes in.
Perfect.
Right? That is also equally important in a service provider agreement. Now, insofar as, again, a product development agreement is concerned, if you come back to a distributor agreement model or a reseller agreement model or a licensing model, what we are essentially saying is that if I have come out with a product, I am sitting here in Gujarat, I am sitting in Rajkot, assume, right? I want to have this product floated in, say, Punjab, right? I might not know how the market is in Punjab. I might not have that vast a network to be marketing my product in Punjab. So therefore, I know somebody like Jaydip who's there in Punjab. Right, he has the necessary amount of bandwidth and the work and the connects and everything. I interact with Jaydip bhai and tell him, ki, Jaydip bhai, I know that you have a very vast network insofar as this product's penetration is considered in Punjab. I would want you to be acting as the exclusive reseller of our product in the state of Punjab.
Perfect.
How do we deal with it? Right, so therefore there are certain territorial rights assigned to Jaydip bhai, to the reseller.
Right.
Now it is very important for the reseller to be first knowing whether he has the right to appoint sub-resellers or not. Right. Now that right again has to be captured in the agreement. Whatever terms are stated in the agreement between the IT, the developer of the product and the reseller in Punjab, similar points will also have to be captured between the in the agreement between the reseller in Punjab and the sub-reseller in Punjab.
Sub-reseller.
Yes.
Right. So therefore Punjab is a state. Now if there's if Amritsar is in Punjab, अमृतसर में एक अलग सब रीसेलर होगा, जलंधर में एक अलग सब रीसेलर होगा, कहीं और एक अलग सब रीसेलर होगा.
Perfect.
So therefore those 5 resellers in Punjab will have to have separate sub reseller agreements, so sub distributor agreements with the main reseller. Distributor and sub distributor. Same terms will have to be made applicable as are applicable in this. If there's a confidentiality clause here, there has to be a confidentiality clause there. If there's an indemnity clause here, there has to be an indemnity clause there. Everything has to run synonymously, toe to toe. Right. And secondly, the very important fact that I have noticed in IT companies, in a product development company per se, is that if supposedly after 2 years of the IT company or the developer being engaged with a reseller, he has created a network of the product that has been developed by the IT company.
Correct.
Right. There are 100,000 or 100,000 users of the said product in Punjab. There are 10 sub-resellers and sub-distributors appointed of the said product in Punjab. Now there is some sort of an animosity या तो अनबन हो जाती है between the IT company and the reseller, and there's a termination of an agreement that happens. The termination clause is very, 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 very crucial, right? What happens if the agreement gets terminated between the main developer and the main reseller of a state?
Okay.
Right? How do we take care of
the
all the sub resellers and the sub distributors and the consumers and the users that are using the product?
सब resellers का किस तरह से maintain करना है?
कैसे maintain करना है? And is it the responsibility of the sub reseller to be ensuring that the transition is proper?
Correct.
Because आप दोनों के बीच में अनबन तो हो गई है, right? So there is a likelihood a reasonable likelihood, I would want to assume, of him or her not cooperating in the process also.
Perfect.
How do we deal with all of that? All of those factors will have to be captured back in the reseller agreement.
Got it.
Right? He'll have to help us.
So, in conclusion, what we learn, what Bhargavji is saying, so you need to keep three things in mind when you are dealing with any parties. Only three things is agreement, agreement, and agreement. So, Bhargav, so when we say agreement, 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 so ये तो हो गया, we deal with internal parties. But how about our partners? How about our HR as in employees or consultant who are technically external but still they are working closely, so non-disclosure and other things. So how we cover that things in agreement? So one with partners, co-founders or partners, one with our HR as in employees, and one with for consultant or contractors kind of stuff.
Understood. So we'll first start with a founders arrangement.
Right.
It's very crucial for founders to have a founders agreement if they have another partner or a director that they're collaborating with to incorporate a company. I understand that there might be certain factors in the agreement which might not be comfortable to be talking upon at the very beginning, at the very inception, because both are full of zeal, right? Or 3, 4, whatever, how many number of partners are there or directors are there. Every director or every founder will be treating the company like their baby. They are very much assuming the fact that there will be no animosity created between the two partners or koi anbar nahi hogi unke aas-paas, right? That is something which is very optimistic. Good. That is a very good thing, very good ideal. But just to safeguard your own rights and just to safeguard the rights of the other partner of yours also in the future, it is very necessary and incumbent for the parties to be having a founders agreement in place. If a founders agreement is there in place, and it is not just dealing with the relationship getting sour. It is not just dealing with that. It is also talking about permanent disability. If one of the partners gets permanently disabled, if one of the partners unfortunately faces a situation of death, if some unfortunate event happens, the families of the partner should also be supported and they should also be clear that what is it that the family is entitled to and if at all they are entitled to something or not.
Right.
So everything should be clear on paper. Just like a partnership agreement is there, you should have a founders agreement also in place which says that yes, this is the main objective of the business. This is the division of roles and responsibilities between me and you. X will be handling the sales part, Y will be handling the delivery part. You can divide the responsibilities and keep it very clear. If there is any additions or addendums or modifications to be made in the same agreement, you can again revisit it, make certain addendums. But then if you ensure that all of that happens,
Very much required.
Very much required.
that is very crucial.
Until unless you have good physics, otherwise it's very much required.
No, but that apart, I have come across many such cases in our state where by the sheer culture and the nature of upbringing, even at the initial stage of entrepreneurship of our state, post-independence, there were quite a few such cases where partners came together and out of 3 or 4 people, one of them died. Then instead of abandoning that family of the person who died, who was one of the co-founder, then rest 2 or rest 3 saw to it by virtue of the whatever agreement that they had drawn out between them in terms of distribution of profit and distribution of the business per se, they saw to it that the family sustained throughout.
Wow.
And when the children of the family came to that age, they offered them that would you like to be part of the business or would you like to take the part and go away? So the backbone was the so-called agreement. If that agreement is there, it morally bounds you. It psychologically also bounds you, and as you rightly said, whether you're physically or otherwise weak or something, then also legally you feel bounded.
Right.
Yeah.
Correct. And moving further, just as you had rightly mentioned about founders, we are then moving forward to employees and the internal systems of the company in place. It is equally important for employers to be having a robust internal employment hygiene check system in their companies.
Correct.
Okay.
Right. It is equally important. And manpower and people are the backbone of any company. No company, no business, no entrepreneurship level can be done. Nothing can be achieved without the help of people. Right. So it is very important for employers and IT professionals per se who are running companies or operating companies to be having a very flexible environment also, to be having an environment that they are offering to their employees which is very conducive and comfortable. But at the same point in time, they also have certain clauses inserted in the employment agreements which are protecting their interests also, wherein certain reasonable restrictions can be added, which are enforceable by agreements, are enforceable in law. Right.
Perfect.
Unreasonable restrictions are required to be avoided. But reasonable restrictions, yes, they can be placed in an agreement, and they've always been upheld by courts of law. Right. So one such reasonable restriction that is there in an agreement is a non-solicitation clause. Right. A non-solicitation clause per se states that if there is an employee of the company, that employee should not terminate during the tenure of his or her association with the company, or after the termination of the said employee from the company, he or she should not solicit certain other employees of the company and take those employees to some other entity or their own new entity that they must have
What we
incorporated.
call as poaching.
Poaching. Right. Now this is employee poaching. You might also talk about client poaching. Right. Now
Correct.
you might
It
also
is
talk
very
about,
common. I mean,
Yeah.
few of you might, if you are watching right now, you might start crying. यार आ तुम्हारी साथ थयलु छे client poaching, etc. I seen plenty of cases.
correct.
So I mean, that's why we invite Bhargav to how to safeguard
The
those things.
non-solicitation clause actually safeguards. I
Exactly.
thoroughly agree with you.
Correct.
Client
And this is
poaching and employee poaching both.
And this is all the more applicable for a senior level employee of the company.
That's
Just
right.
imagine that a sales personnel of the company, he may be a senior level one or not a senior level or a junior level or subdivisional level one also. But the sales personnel of the company are prone to be receiving certain additional amount of confidential and proprietary information of the company.
Correct.
They are prone to be getting access to the client lists. They are prone to be getting access to all of those people who are in those clients, the name of the company. Suppose it be Microsoft, he might know Bill Gates also. The
Right.
sales personnel of the company might know the main person in those particular companies. So it should never be. Therefore, there is a reasonable restriction that is required to be inserted in a contract, more so when you are entering into a contract with a sales personnel of the company, as to what are the restrictions that are imposed upon the said person after he or she terminates his association with the company, and what is the said person required to do during his association with the company also. So those factors will have to be captured in the employment agreement of the said employee. Right. In addition to that, confidentiality is a very major clause. Right. So the confidentiality clause can even extend for a very long duration after the person or the employee terminates his association with the company also. तो कल जाके it can never be the case कि आज वो आपकी कंपनी में काम कर रहा है, आपने उसे 10 चीजों की इंफॉर्मेशन दे दी है, just because he leaves the company, it is not so that he can utilize the information for his own benefit or he can disseminate the information to somebody else.
Does it include gossiping as well?
If in the course of him having gossiped in the company, if he has become privy to certain confidential information of the company, it does include. It may include.
Gossip करते करते confidential बात निकाल दी.
It may include.
Many people are very good at that.
They
It
do,
includes
they do, in fact.
confidential clause per se. We tend to include even verbal and non-verbal communication.
Perfect.
It is not just limited to verbal, non-verbal, or it is even also extended to verbal communications. Right. So anything is included. So you can also have a confidentiality clause crafted in a manner wherein the confidentiality clause extends till perpetuity. Right. So therefore, whenever the employee resigns from the company or his association is terminated with the company, there is generally a clause that we insert that he will have to destroy all the information that he has, or he will have to return all of that information back to the company and give a disclosure letter or an exit undertaking to the company that yes, I know that there is a confidentiality clause in the agreement that I had signed long ago when I joined the company.
Right.
The same thing is being reiterated. Right. So whenever any employee exits from the company, it is suggested
should be.
that
It
we
should
have an
be.
exit undertaking in place or an exit separation cessation agreement in place.
Correct.
Wherein the exit agreement is merely reiterating the contents of the employment agreement, and if there are certain facts and circumstances that are pivotal or that are useful or that came to light only at that stage when he is exiting the company, those can be added in the exit agreement.
So yeah, exit undertaking is genuinely a good practice, a very nice practice to everybody should. At any even initial stage में जो young company है, startup है, they should also have this in place.
Correct.
And एक ये बात जब चल रही है हमारी, तो normally हम लोग एक term use करते हैं cooling period. मान लो somebody who is working with me और हमारे competitor company, suppose he is the competitor company, यहाँ से कोई बंदा वहाँ गया एंड नोइंगली म्यूचुअली इज एग्रीड कि भाई फाइनली मैं पूछ के सब बता के जा रहा हूँ बट येस आई एम गोइंग टू जॉइन अ कॉम्पिटिटर एंटिटी द कॉन्फिडेंशियलिटी क्लोज एंड एवरीथिंग इज रीआइटरेटेड एक कूलिंग पीरियड वाला मुद्दा भी, if you, I know you would have come across. So what is kind of a, is there practice which is kind of been accepted by the law, or is it something which is part of the agreement or should be part of this undertaking? If you can,
So essentially,
थोड़ा सा उसके बारे में बताओ.
Sure. So what I understand from you, Pranav ji, is that we are saying that after he terminates his association with the company, I wouldn't want that particular employee or my ex-employee of the company to be joining a competitor for a defined period that we are defining as a cooling period. Correct. Generally, that cooling period is there and accepted as a norm in employment agreements and contracts, which is termed as garden leave.
अच्छा.
Right. So a garden leave is essentially a concept which is recognized in law in India also very lately. It's a new concept, right? So garden leave essentially means that that particular person should not join a competitor company or any other company that the previous employer decides for a salary that is offered or some amount that is offered to the said employee.
Okay.
So essentially, in all light, on a lighter note, it is essentially said to that particular employee that you please sit at home, do not work anywhere, right? But we will pay you certain amount of money for not working also, right?
So
this
who
may
pays?
happen.
Who pays?
The
Employer.
ex-employer.
Ex-employer. Till he finishes his so-called cooling period.
Till the employer is satisfied that that particular person is not going to be committing any activities which are not recognized as per the agreement or which might constitute to be a breach of the clauses of the agreement.
Receiving end, सभी जगह पर.
So young entrepreneur might able to understand X is always expensive.
So that is one concept. The second thing is that it is very important for all employers, irrespective of the size of the company, irrespective of how big or small you are, it is important to have an HR policy handbook.
Perfect.
Right. Please have all your internal policies and human resource policies in place. These are statutory policies also and recommended policies also in the company. There are certain statutory policies. You should have a maternity benefit policy. You should have a prevention of sexual harassment at workplace policy. You should have an equal opportunity policy. All of these policies are mandatory. But then you can have certain other recommended policies also in the company that you can have as a code of conduct policy. You may have a disciplinary committee policy. So all of those things regulate that if at all there is any issue that occurs in the course of the association of the employee in the company, how is it supposed to be dealt with?
Perfect.
There is a mechanism that is there. So therefore, the employee is also privy to all of those policies. And if they want to be raising any grievance, they have the entire system that is laid out in the policy document. They merely have to be referring to the policy document, escalating the issue to the concerned person mentioned in the policy, and they can move forward and resolve it.
So if you're listening and if you feel कि इसके लिए separate podcast design करें, which is about especially HR policy in terms of ethical, moral things, legal things, code of conduct, etc., etc. So comment here. We want HR policy kind of comment, so we can read it.
Categorically, employment contract.
Employment contract as well.
Employment contract is up because now with so-called hybrid mode in place,
Correct.
we need lots of retweaking here and
Yes,
there.
yes.
Law probably is mandating something which at times is not feasible to adopt in the hybrid mode. So how to take care of that? So I think employment contract के बारे में ज़रूर एक अलग से dedicated
Yes, yes.
podcast होना चाहिए where जो primary level जो हमें सिखाया जाए, बताया जाए, that can serve as a template for many
Perfect,
company.
perfect.
एग्जिस्टिंग कंपनी को भी सुधारने के लिए एक और चीज़ पूछनी थी आपसे कि जो भी ये डॉक्यूमेंट्स हैं बने हुए हैं जहाँ पे, तो हाउ फ्रीक्वेंटली दे शुड बी रिविजिटेड बिकॉज लॉ चेंज होते रहता है, सर्कमस्टेंसेस चेंज होता रहता है, द वे इन विच बिजनेस इज बीइंग कंडक्टेड वो भी चेंज हो रहा है. बिफोर कोरोना, पोस्ट कोरोना इज अ क्लासिक थिंग दैट वी आर टॉकिंग, राइट? तो वो सिचुएशन में आप कैसे एडवाइस करते हो? बिकॉज वर्ल्ड इज आल्सो चेंजेस.
Correct.
Tech fraternity changes in a very dynamic way.
Correct. So having said that there is dynamicity that is involved in the entire segment. It is equally important for that dynamicity to be captured in the employment agreements also. But the one grievance that may be raised by the employee whenever you're changing the nature of the agreement is that the employee wouldn't want certain addendums or modifications to be made in the employment agreement which were previously to his benefit, but now after the addendum are not in his benefit. Right? So that is one struggle that he'll have to face, wherein that can only be resolved through negotiation.
Negotiation.
You have to negotiate. Because when the employee will join, supposedly I am joining a particular company, assume that I am not a lawyer and a tech professional. I join a particular company and I must have joined at a junior developer stage. over the period of time, I might become a senior developer, a joint developer, a very senior level officer, and a vice president of the company. Obviously, the same employment agreement that was applicable to me at the time when I was a junior developer cannot be made applicable when I am a vice president of the company. And the time frame that is there from me progressing from a junior developer's role to a senior vice president's role is also a large window of time.
Correct.
So that window of time will also have to be factored in to make certain amends. And the same thing will have to be explained to the employee also in a very nuanced manner that yes, the situation has changed, the circumstances have changed, the times have changed, your role has changed. So therefore the agreement has to change.
I think two things we need to do. जयदीप भाई आप जो बोल रहे थे उस एक तो एम्प्लॉयमेंट कॉन्ट्रैक्ट और एक ओवरऑल कॉन्ट्रैक्ट
Exactly.
क्लाइंट के साथ क्योंकि जहाँ पे अननेसेसरी डिस्प्यूट्स and then go to disputes redressal वो सब होता रहता है.
Correct.
तो वो दो चीज डेडिकेटेड हमारे कलीग्स जो हैं.
So if you are listening to Pranav bhai and if you feel so, keep suggesting us what next podcast we should plan. We already have some funnel design, but if you think this is very much important, this should be prioritized out of our funnel, we'll try to prioritize that. That is what our chairman want to convey.
Yeah. Right? I think with that we can probably go for a.
Bhargav, as we are coming end to the podcast, I just want to understand, being a Gujarati, we want free resources. So, if few of my colleagues might not able to afford you or people like you,
No.
so
I would want to be considered as a person who's very affable. Please approach us. Not a problem at all.
or if they're starting and they want to cover, so is there any some resource pool where they can check? और AI तो वो तो ले लेंगे, IT वाले AI का तो benefit ले लेंगे, but AI might not help because laws is very different country to country and subject to subject. तो ऐसा कोई जगह है वहाँ से बेसिक चीज़ें कुछ उनको मिल जाए टू स्टार्ट विद एंड देन इंटरनेट पे सर्च करने से मिल जाएगा. बट इफ़ यू कैन सजेस्ट सम गुड पूल that might help them to understand basic thing, फिर वो आपके पास of course आएंगे.
I think the pool that can be helpful here.
Before you
Sure.
एक चीज जो हम लोगों ने as part of GESIA ही हमने जो इनसे बात की है कि ये जो राउंड टेबल की हम बात करते हैं इन पर्सन या तो हेल्प डेस्क, फॉरगेट राउंड टेबल, इट विल बी मोर ऑफ हेल्प डेस्क. Every HR of the company, of all GESIA member company, to that matter any tech company of Gujarat,
Right.
every HR, every legal, every company secretarial entities within the companies, whether they are having those relevant legal degree or not, law degree or not, but in case if whatever they would like to come back, the doors of GESIA are open. Through them, they can always correlate and kind of confide with Bhargav ji and approach him also. We'll fix a couple of dates, every fortnight or every once in a month or every once in a fortnight,
Sure.
where we receive this kind of queries. In person हो सकता है, web पे हो सकता है,
Right.
and he can be there to guide. So that is one way of doing it. वो जो आपका help वाला point है,
Absolutely.
free resource वाला.
So Pranav has solved very beautifully कि आपको सर्च भी नहीं करना, कुछ नहीं करना, you just pick up the phone, call Tirup or Pranav bhai or you shoot email to team GESIA.
सीधा ही GESIA secretariat
GESIA secretariat आप
GESIA.org.
email कर दीजिए and we'll try to accommodate those things. So Bhargav, we are skipping those questions.
No, he wanted to say something. Let him do so.
नहीं, not a
But
problem.
no, please आप बोलिए. लेकिन secretariat@gesia.org is the classic email that they should go for.
Perfect.
Right? And वहाँ पे हम queries receive करेंगे. We'll pass it on to him. And he will fix a date by which he can come back. तो वेब पे ही बैठेंगे जो लोग बाहर गांव से हमसे बात कर रहे हैं, जो हमारे कलीग्स हैं, मेंबर्स हैं, और जो लोग अहमदाबाद में हैं, and if they would like to come in person, whether they are GESIA member or not, we are there.
Perfect.
But we all want every one of them to become GESIA member for sure. Not that GESIA feels that it should be donation बड़ा करना है इसलिए member बनो, ऐसी बात नहीं है. पर जितने लोग साथ में आएंगे उतना ही ये सब चीज़ें इंटरेक्शन होगी, डेलिब्रेशन होगा, तो मोर एनरिचिंग एनवायरनमेंट खड़ा होगा सबके लिए, सबके बेनिफिट के लिए. सब बेस्ट प्रैक्टिसेस शेयर करेंगे, चैलेंजेस शेयर करेंगे, एंड पीपल लाइक हिम एंड यू आर ऑलवेज देयर टू हेल्प अस आउट.
Sure.
Sure. So
You
since
wanted to say
Pranav ji, you had already pointed out something regarding the master service agreements that we have with our clients. I was wanting to, since we are nearing the end of the session, I was quickly wanting to accommodate certain aspects of the MSA that might be crucial for the listeners here.
Please,
Right,
go ahead.
if we have the time. time permits.
Parting tips.
Yes, parting tips. So one very important factor that we should have in an MSA is limitation of liability. So the abbreviated version on a very lighter end, limitation of liability is LOL. Right? That means laugh out loud. Right? But whenever the agreement is misconstrued or whenever the agreement is not drafted or crafted in a lucid manner, the other party will be laughing out loud.
And we,
Right?
will be crying, and we will be crying out loud.
So, on a serious note now, the limitation of liability clause essentially prevents the parties to be having certain unlimited exposure in terms of monetary liabilities on them. Right?
Perfect.
There are two restrictions that are placed in the limitation of liability clause. One is the amount of liability, the quantum of liability. Second is the nature of liability, type of liability. So, quantum of liability essentially states that just because something might have gone south while implementing the terms of the agreement that ultimately might have resulted into a loss to either of the parties, it should not be the case that I am unlimitedly liable to any number. That cannot be 100,000 crores.
Merely because it has gone wrong.
Exactly, merely because it has gone wrong. There has to be some explanation to it. So therefore, we advise all parties to have some formulae that they devise, which is either in general cases dependent upon the service fee involved in the agreement or a multiple of the service fee involved in the agreement.
9 hours. And
Right, 9 hours. Whatever compensation structure is, you can devise something around it and you can mention that formula in the agreement.
That's a very good
Perfect.
suggestion.
Super.
That is one. Second, even important, is that to what extent are you liable in terms of damages? Right, in terms of type of damages. Are you only liable for direct damages or are you liable for indirect, consequential, incidental, all of these damages?
Extremely important.
Extremely important. Right. So, I'll just give you a very hypothetical example here. आज जाके एक IT company ने एक service provide किया to a client of its. Now, after having provided the service to an extent, the IT company also faced certain difficulties in providing this service because of some non-cooperation on the side of the client also, which is not yet adjudicated and decided. There is some problem that has occurred between the two parties, which ultimately resulted in the client not being able to fulfill its obligation that it had promised to certain other people. अभी कल जाके एक क्लाइंट ने बोला था कि मैं ये सोल्यूशन जो आईटी कंपनी से बनवा रहा हूँ उसको मैं एक लेबल कर दूंगा किसी XYZ कंपनी का और एक 10 लोगों को आगे जाके मैं वेंडरों को क्लाइंट को बेचूंगा. ये मेन सॉफ्टवेयर ना बनने के कारण आगे वो 10 क्लाइंट वो लूज आउट हो गया. Right, because of the loss that he has faced of not receiving revenues from all of those 10 clients that he had promised to, that incurred a loss to him of say 500 crores. That 500 crores liability is a consequential loss that is then transferred upon me if it is not captured in the agreement, that the agreement excludes it.
Right.
Right. So therefore, the agreement should be limited to direct losses.
That reminds me, I mean, a few time back, one cybersecurity company updated few things and across the world,
That is exactly.
many airports shut down to issue manual tickets, etc. So that is the exact scenario he wanted to describe. So last question for
Yes,
me is, there are lot many myths in legal as well. ऐसा चलेगा ऐसा नहीं चलेगा kind of stuff. So I just want to highlight one or two myths which we as a IT companies or we as a tech company think ऐसा तो होता ही है. But during your journey you realize कि सबको ऐसा लगता है but ऐसा actually होता नहीं है.
बिल्कुल सही बात है. So one such myth that comes off the cuff to my brain is having a document which is concise. Right. So I am very sure of the fact that a lot of IT companies are cognizant of the fact that to incept a relationship with a client or a vendor or a consultant, you need an agreement. वो बात है. Everybody is cognizant of the fact कि एक agreement की आवश्यकता है. But कैसा agreement की आवश्यकता है? That is the question.
Right.
So merely the requirement of an agreement may not be sufficient, may be sufficient in some instances depending upon the relationship of the parties. But in cases where the other party is unknown and the other party is a distinct third party with whom you are wanting to develop a professional relationship, it is advisable that you have a well-crafted agreement.
Perfect.
Merely the existence of an agreement may not be sufficient. A well-formulated agreement is the need of the hour. Right. So I'm wanting all IT companies or any company for that matter to be cognizant of the fact that you should have a very well formulated agreement that deals with every eventuality and envisions every problem that might happen in the future.
So in nutshell, Bhargav want to convey us internet से download किया agreement नहीं चलेगा.
Yes,
You
completely.
You should have some legal person to check it, review it, and tweak it accordingly your needs. So Bhargav, thanks for your time.
Thank you.
We might invite you for one more podcast as well.
Sure.
Pranav, your parting words.
Parting words. What I feel after hearing him, and which I normally also like to say on and often. common sense, which is sort of a rarity now, but it's the only way out while dealing with the fact in terms of running a company or running an association or running a day-to-day life also. The agreements and the legalities that Bhargav ji was basically trying to convey to all of us was, if you look at it very in a very soft or a distinct manner, what he's trying to tell you is that जो भी आप करो वो थोड़ा सा कॉमन सेंस अप्लाई करके करो. खाली आपकी ओर की ही बात मत देखा करो, दूसरी साइड की भी बात देखो. दोनों चीज सामने लाओ, फेस करो उसको और उसका रिजोल्यूशन भी लाने की कोशिश करो. सो आई थिंक दैट्स द वे टू गो. वेरी नाइस वे ऑफ कंडक्टिंग दिस. मुझे बहुत अच्छा लगा ये कन्वर्सेशन.
Pleasure to be here, sir.
एंड वी शुड हैव दिस ऑफन. वेरी नाइस द वे इन विच यू कंडक्टेड. थोड़ा सा और ह्यूमर लाओ. आपका जो वन लाइनर है उसका थोड़ा और ज्यादा यूज कर लो.
When you're saying common sense all the things, so that occurs in my head. I keep on saying for AI. Somebody asked me, can AI beat human? I say AI never able to beat human stupidity. So कुछ ना कुछ तो stupidity करते रहेंगे. So in terms of legal as well. So like Bhargav rightly mentioned कि internet से download का agreement might not work. And हमें वही perception से चलना चाहिए कि ये शायद नहीं करेगा. So what use cases we discuss. Now you try to relate all the things which we discuss in podcast. So if you love this podcast, share with your friends, comment on that, subscribe तो of course करना ही है आपको, वरना प्रणव भाई फोन करेंगे आपको.
No. It should be candid. Let them come on their own.
Sure. So thanks for your time. Thanks for watching, and we'll keep meeting. Thank you.
All of you. Thank you very much. Bye-bye.